Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. It is Sunday, the 25th of January, 2026, and as we look at the docket in Idaho versus Kohberger, we see that the documents under seal for the months of January, February, and March 2025 ordered to be released to the public well over a month ago on December 18th, 2025, still have not yet been released. This relates to court order dating approximately 100 days ago, October 16th, 2025, where Judge Hippler went to both sides, responsible for the filing of so many documents under seal, either by submitting motions to seal something or other, many times evidence, on their own or together. They had their opportunity to be heard. They filed their responses to the October 16th, 2025 order, and here we are all these months later in a case that has been closed for over a half year. We have been covering other criminal cases as well, such as the Allen versus Indiana appeal, the Delphi case. We've been covering State of California versus Reiner, where Mr. Reiner has been alleged to have committed unalivings of his parents, Hollywood director Rob Reiner, and his wife, Shel Reiner, a photographer and producer. We must always point out that Mr. Reiner, as is every defendant who is prosecuted for any crime in the United States, is considered under the eyes of the law to be innocent of all charges until or unless one of two things happened. Either the defendant goes to trial, is adjudicated guilty, or agrees to plead guilty. Speaking of pleading guilty, we've spent time over the course of the past several months looking at documents that finally started to become unsealed in this very high sealed Kohberger case, and trying to come to some understanding, number one, why the case was sealed as it was, why Mr. Kohberger decided to plead guilty when all indications were he was going to trial, with his attorneys going so far as to saying he was factually innocent, and why it was the state of Idaho felt there were no other co-conspirators, alternative perpetrators, accessories before the fact, accessories after the fact. And we're going to continue to do that because, in our opinions, trials were always intended to be open to the public, not sealed to the extent that this one was, with gag orders and so many hearings behind closed doors on top of the many documents that were and still are under seal. But as it relates to Mr. Kohberger and any concerns that the public may have that he is not the sole, nor is he the correct defendant in the case, it is likely nothing will change on that score because of his signing of a plea agreement where he agreed to waive his appellate rights. Now, there are certain limited situations where the legal standard is that a party can come back later and challenge a guilty plea with waiver of appellate rights if, for example, they can show that there was ineffective assistance of counsel, but that's about it. Things are possibly going to change if a certain party who did plead guilty and signed away his appellate rights is successful in a case that is before the United States Supreme Court right now. It is Hunter versus United States. What Mr. Hunter is seeking to convince the Supreme Court of the United States is to change the legal standard. Under the Constitution, the Supreme Court is the ultimate authority as to what the Constitution says or doesn't say. And Hunter wants due process of law, the guarantees under the Constitution of notice of what it is that the government is seeking to put someone in prison or take away other liberties, including life, an opportunity to be heard in defense of those charges, and cornerstone of our entire criminal justice system, a right to a fair judge and jury when it's a jury trial. Those considerations are not applicable across the land when someone seeks to still appeal a plea agreement where they've agreed to waive appellate rights. This case is getting the public to think, are there certain things that should not be waived against public policy? Is waiving constitutional rights, such as due process, against public policy? Those are the types of issues that are going to be before the Supreme Court at oral argument March 3rd, with a ruling that is due before the end of June of 2026. So I encourage you, if you have an interest in cases where defendants have pled guilty and waived their appellate rights, please keep your eye on Hunter versus United States. Until next time, this is Kathy. Thank you for joining us here today.